He was still in bed, 66 years old, woken by the sound of unmarked police cars pulling up to his rented house in Norfolk. No warning, no courtesy call to the palace, no message to the King of England. 8 o'clock in the morning, and Andrew Mountbatten Windsor was placed in custody. The charge wasn't what the world had been waiting for. It wasn't what the headlines had promised for years. The Thames police weren't there about the girls. They were there about the emails. And what those emails allegedly contained could put a former British prince behind bars for the rest of his life. Let's establish what is confirmed. Andrew Mountbatten Windsor, formerly styled as Prince Andrew, Duke of York, was arrested on the morning of his 66th birthday at a private residence in Norfolk, where he has been living whilst his primary home at Royal Lodge on the Windsor estate undergoes renovation. Thames police conducted the arrest on suspicion of misconduct in public office. Multiple properties linked to Andrew were simultaneously searched. He was taken into custody and held for several hours before being released. No formal indictment has been issued at the time of this broadcast, but what investigators are examining, what allegedly sits at the center of this case, is a decade of communications between Andrew and Jeffrey Epstein. Specifically, a tranche of unsealed Epstein-linked emails, including correspondence from November 2010, in which Andrew allegedly forwarded sensitive, confidential reports relating to official trade visits to Vietnam, Singapore, and Afghanistan. Reports generated through his official capacity as the United Kingdom's Special Representative for International Trade and Investment, a position he held from 2001 through 2011. If those allegations are substantiated, they could constitute a violation of the Official Secrets Act. And under that statute, a conviction carries the possibility of a life sentence. There is something important to understand before we go further. This is not a settled matter. Andrew has not been formally charged. The allegations are serious, but what investigators can actually prove, and in a courtroom, to the criminal standard, remains an open question. But the arrest itself, that has already changed everything. The role of special trade envoy was not Andrew's idea. According to accounts that were circulating long before this arrest, it was Queen Elizabeth who pressured the Foreign Office into giving her son the position. The Foreign Office, by its own internal communications, did not want him there. Those concerns were documented. A letter sent by the Foreign Office to the then Prime Minister reportedly expressed in clear terms alarm at the people Andrew was meeting with, the manner in which he was conducting himself, and the risks his conduct was creating. He was, according to those who worked around him, something of a liability. Described internally, it is alleged as a buffoon. And yet the role continued. Think about what a decade in that position actually means. Andrew had access to classified trade intelligence that would be unavailable to almost any private individual. He sat in rooms with heads of state, with foreign ministers, with sovereign wealth fund administrators, with the kind of people who do not take meetings unless the person across the table carries genuine institutional weight. He carried that weight. He carried it because of his surname. What is now alleged, and this is framed by investigators as allegation at this stage, is that intelligence gathered through those meetings did not stay in those rooms. It allegedly went, sometimes minutes after being received, to Jeffrey Epstein. The November 2010 emails, now unsealed as part of the broader release of Epstein-linked documents, reportedly showed Andrew forwarding those sensitive trade reports almost immediately upon receipt. The destinations covered in those reports, Vietnam, Singapore, Afghanistan, were not holiday destinations. They were sites of official British economic and diplomatic activity. What was being relayed was, at minimum, confidential. At maximum, the investigators appear to believe it could constitute state-level disclosure to a foreign-connected private individual. Why would Epstein want that information? That question, as of now, does not have a confirmed answer. In 2019, Andrew Mountbatten Windsor sat down for a televised interview, one the royal family reportedly urged him not to do, and denied almost everything. He denied meaningful ongoing contact with Epstein after becoming aware of certain allegations. He denied events that specific witnesses and photographs had placed him at. He claimed, memorably, that he had simply no recollection of a particular photograph ever being taken, a photograph in which he appeared to be present. That interview was, at the time, widely regarded as a disaster. What investigators now appear to be building a case around is something more specific. They are not using that interview to embarrass him. They are reportedly using it as evidence of a sustained pattern of false statements, because the emails now unsealed appear to contradict, directly, claims Andrew made on camera and under public scrutiny. A man who told the world he had distance from Jeffrey Epstein was, the documents suggest, forwarding him classified reports. The Virginia Giuffre civil case settled in 2022 for a reported figure of £12 million. 1 million of those pounds, it has been reported, came from King Charles. That settlement carried no admission of wrongdoing, but it resolved one avenue of legal exposure, and it has been widely observed that it removed, at least temporarily, the most publicly discussed allegation from active litigation. The misconduct in public office charge takes a different route entirely. It is not subject to the same statute of limitations considerations. The alleged conduct, sharing confidential trade documents, is documented in writing. Emails, by their nature, leave records, and those records are now in the hands of investigators. What they allegedly show goes beyond the November 2010 correspondence. It is alleged, and verification is pending on the full scope of this, that Epstein used his relationship with Andrew to access things money alone could not buy. Private tours of Buckingham Palace, access to senior figures in the British royal household, meetings with visiting foreign dignitaries, meetings that, it is alleged, the royal family would never have formally sanctioned and did not publicly acknowledge. Epstein's network, as it has been described by those who have studied the Epstein files extensively, operated on the currency of access. Access to powerful people, access to sensitive environments, access to information. Andrew, it is alleged, was providing all three. Now, consider another name that has emerged in connection with Andrew's circle, Yang Tengbo. Previously known in legal proceedings only as H6, due to anonymity protections that were subsequently lifted. Yang Tengbo is an individual whom British intelligence has characterized, and Yang Tengbo denies, as an operative with links to Chinese intelligence. The precise nature of Andrew's relationship with Yang Tengbo has not been fully established in public proceedings, but the question it raises, what did a former British trade envoy discuss with someone subsequently identified by security services, is one that investigators are not finished with. This is where the case begins to feel less like a scandal and more like something else entirely. What was passed? To whom? The simultaneous searches of multiple properties linked to Andrew were not ceremonial. Officers were not there to take photographs. They were there looking for specific categories of material: laptops, hard drives, physical documents. Anything that could corroborate or complicate the picture being assembled from the Epstein email archive. Here is why that matters. The Epstein emails released so far represent one end of the correspondence, Andrew's end. What investigators are now attempting to locate in properties Andrew controlled or occupied is the documentation on the other side of those exchanges. Notes, drafts, records of what was received, what was requested, what was acknowledged. Because if the emails show Andrew sending, the next question is whether there is evidence showing what came back in return. That question has not yet been answered, and the answer, when it comes, may determine whether this case stays at misconduct in public office or becomes something considerably larger. While the arrest of Andrew Mountbatten Windsor dominated proceedings, several other cases are developing simultaneously and warrant attention. In Tucson, Arizona, the investigation into the disappearance of 84-year-old Nancy Guthrie, who was reported missing from her home on February 1st, has now entered its third week with no resolution, and more significantly, with a visible conflict of authority emerging between the Federal Bureau of Investigation and Pima County Sheriff Chris Nanos. Federal officials are reportedly pressing to assume primary control of the investigation, citing concerns about the early clearing of the crime scene, which allowed media access, and delays in deploying aerial search resources attributed to staffing shortages. Physical evidence recovered to date, including discarded latex gloves and surveillance footage of a masked individual near the property, has not yet yielded any identified suspects. Sheriff Nanos has pushed back against characterizations of mishandling, but the reported history between his department and the FBI, stemming from a dispute over asset forfeiture funds in 2015, has added a complicating dimension to the jurisdictional tension. The FBI's ability to formally assume control remains contingent on authorization from Guthrie's family. No arrest has been made. In a Polk County, Florida courtroom, 70-year-old Richard Ferguson was sentenced to 444 months, 37 years, following his conviction on 4 counts of manslaughter. The charges arose from a September 3, 2023 incident in which Ferguson's 15-year-old son, driving a vehicle without authorization, struck a car carrying Trinidad Hernandez and her 3 grandchildren. All 4 died. At sentencing, Ferguson delivered an emotional statement of remorse, acknowledged he should have intervened, but denied having provided the car keys or permission to drive. Judge Wayne Wooten imposed the full term. Ferguson's family had sought leniency on the basis of his advanced prostate cancer diagnosis. The victim's relative, Sabrina Hernandez, testified to the lasting devastation. Ferguson's son, sentenced separately as a juvenile, is scheduled for release at the age of 19. In Sherman, Texas, a 36-year-old dentist identified as Dr. Buck was arrested on February 18th following reports of suspected intoxication at a pediatric dentistry clinic. Police were called around midday, discovered Dr. Buck displaying signs of impairment, and confirmed she had treated at least 1 child patient that morning. She failed field sobriety tests. A blood sample was obtained via warrant. The charge, a state jail felony under Texas law, carries a potential sentence of up to 2 years. Dr. Buck had been employed at the clinic on a temporary basis through a staffing agency, held no prior disciplinary record, and had been licensed as a dentist since 2016. She was released on a bond of $10,000. Police described the case as without precedent in the area, and in New York, 24-year-old Noah Roberts Huffler of Rochester now faces felony charges following his arrest on allegations of sexual abuse involving multiple child victims at a local daycare facility. Incidents reportedly occurred outside supervised settings. The daycare's identity is being withheld to protect the victims, whose ages range from toddlers to preschool age. Investigation into the alleged pattern of conduct is ongoing. Return now to the case of Andrew Mountbatten Windsor, because the legal architecture around it is worth examining carefully. Misconduct in public office is not a minor charge under English law. It is a common law offense, meaning it is not defined by statute, but by centuries of case precedent, and it applies to public officials who willfully neglect their duty, abuse their position, or act in a manner sufficiently serious to amount to an abuse of public trust. It carries at the upper end an unlimited sentence. Life imprisonment is within scope. What makes this charge particularly significant in Andrew's case is its relationship to the evidence type. Unlike allegations of personal misconduct, which often rest on witness testimony, credibility assessments, and the passage of time, the alleged forwarding of classified documents is, at its core, a paper trail, or in this instance, a digital one. Emails have metadata, they have timestamps, they have recipients, they have content. They are, in the language investigators prefer, objective. Andrew has not been formally indicted. He is not currently facing trial. What has occurred is an arrest on suspicion, which under English law permits detention for questioning and, crucially, the lawful search of associated properties. The investigation is, by every available indicator, in active progress. The response from senior royals has been measured but notable. King Charles III issued a formal statement affirming that the law must take its course and pledging full cooperation. William, Prince of Wales, and Princess Catherine have also publicly aligned with that position. Queen Camilla declined to comment when approached. The princesses Beatrice and Eugenie have made no public statements. Sarah Ferguson, Andrew's ex-wife, is reportedly traveling abroad. King Charles, hours after his brother's arrest, an arrest, it must be noted, of which he reportedly had no advance knowledge, attended a fashion event in London. His first appearance at London Fashion Week. The public visibility appeared deliberate. The Prime Minister also issued a statement. The substance was brief. Nobody, it said, is above the law. What comes next in the Andrew case will depend in large part on what the property searches yield. Investigators are looking for material that can either corroborate the documentary record already assembled from the Epstein email archive or expand it. If correspondence exists showing Andrew receiving acknowledgement, compensation, financial or otherwise, or instructions from Epstein in exchange for the alleged disclosures, the case would move into substantially more serious territory. If the searches return nothing that advances the allegations, the picture becomes more ambiguous. The decision on whether to formally charge Andrew Mountbatten Windsor sits with the Crown Prosecution Service. They will assess the available evidence against the legal threshold. Is there sufficient material to create a realistic prospect of conviction? Is prosecution in the public interest? Both conditions must be met. Neither has yet been determined. There are questions this investigation has not yet answered and may not answer quickly. What, specifically, did Epstein do with the information he allegedly received? Who else, if anyone, received it from him? What relationship, precisely, existed between Andrew and individuals subsequently identified by security services as persons of concern? And what did people within the royal household, or within government, know, and when did they know it? Those questions are not speculation. They are the documented concerns of investigators and members of Parliament on both sides of the Atlantic, where calls for Andrew to testify before the United States Congress regarding his ties to Jeffrey Epstein have also emerged. The Epstein files, as they continue to be released, appear to have served as the catalyst that drove this arrest. They provided investigators with a level of documented specificity, names, dates, content that allegations alone had not previously delivered. Andrew Mountbatten Windsor spent a decade as a British trade envoy. He had access to information that very few individuals in any country are ever granted. The allegation before investigators is that he used that access in ways that benefited Jeffrey Epstein. What Epstein did with whatever he received, who else it reached, what damage it caused, is a thread that is still being pulled. The next procedural step will clarify whether formal charges follow. Until that decision is made, the investigation continues. Properties are being searched, documents are being examined, and for a man who spent the better part of 3 decades operating in the shelter of royal protocol, the world outside those walls is operating on a very different set of rules. The law, as the king himself has now said, must take its course.